Want to take guns out of the hands of law-abiding citizens.
We've been rewriting it, and we are going to bring in something called the Gun Violence Restraining Order. That law enforcement will have 72 hours to determine whether they should give those guns back or they can go to a judge.
The Department of Justice just filed a legal brief so shocking that gun owners across America are questioning everything they thought they knew about their rights. This isn't about some minor policy disagreement or bureaucratic red tape. This is about a complete betrayal of promises made to millions of law-abiding citizens who believed their government was finally on their side. What started as celebration has turned into disbelief as the DOJ's true intentions become clear. The same officials who promised to defend the Second Amendment are now using legal arguments straight from the playbook of the most anti-gun courts in America. And they're doing it in a way that could fundamentally change how the government tracks, monitors, and controls firearm ownership forever. The story begins with hope. Back in January, gun owners were hearing promises that seemed almost too good to be true. National reciprocity was supposedly racing through committees. Constitutional carry was spreading from state to state, with federal support finally materializing. Most importantly, the despised NFA tax that had been strangling suppressor ownership since 1934 was about to vanish completely. These weren't vague campaign promises or wishful thinking from advocacy groups. Concrete legislation was moving through Congress. The whispers coming from Washington suggested real change was happening. People weren't just hopeful anymore. They were making actual plans based on what looked like inevitable victory for gun rights. When Pam Bondi was selected to lead the Department of Justice, the celebration intensified. Here was a former state attorney general with a reputation for understanding constitutional rights. The confirmation hearings went smoothly, the speeches hit all the right notes. Gun rights advocates were convinced they finally had an ally in one of the most powerful positions in government. Then came the legislative victory that seemed to validate all that optimism. The One Big Beautiful Bill passed with a provision that completely eliminated the NFA tax on suppressors, short-barreled rifles, and short-barreled shotguns. Not reduced or reformed, eliminated. The tax dropped from $200 to $0 overnight. Gun rights organizations immediately recognized what this meant legally. The National Firearms Act had survived constitutional challenges for 88 years based on one specific legal theory. Congress could use its taxing power to regulate certain firearms. Remove the tax, and you remove the constitutional foundation for the entire regulatory scheme.
The U.S. Department of Justice is suing the L.A. County Sheriff's Department, accusing it of violating people's Second Amendment rights.
Constitutional scholars and Second Amendment attorneys started preparing challenges immediately. The logic was straightforward and seemingly bulletproof. If the only reason the NFA survived judicial review was the taxing power justification and Congress just removed the tax, then the entire legal foundation collapses. It's not complicated constitutional theory, it's basic law that first-year students learn. But the Department of Justice had other plans. Instead of acknowledging the obvious constitutional implications, they marched into federal court with arguments that left even seasoned attorneys speechless. Their position was essentially that the tax elimination doesn't matter because Congress still possesses the abstract power to tax, even if they're not currently exercising it. Think about that for a moment. They're arguing that the mere possibility of taxation justifies a comprehensive federal registry even when no tax exists. It's like saying the government can enforce speed limits on roads that haven't been built yet, or collect property taxes on land that doesn't exist. The logic defies common sense and established legal principles. The brief they filed in the Silencer Shop Foundation case wasn't a routine legal document. It was 48 pages of aggressive arguments designed to preserve every aspect of the NFA framework, regardless of what Congress had just done. Page after page contained fallback positions, alternative theories, and creative interpretations that would make any gun control advocate proud. What makes this particularly disturbing is where they went looking for legal support. The DOJ's brief cites the Ninth Circuit Court of Appeals 17 times. For those unfamiliar with federal courts, the Ninth Circuit has the worst track record on Second Amendment cases of any appellate court in the country. They've upheld magazine bans, assault weapon prohibitions, and permit schemes that effectively denied carry rights to everyone. The Supreme Court has reversed the Ninth Circuit on gun rights more than any other circuit. So when a supposedly pro-Second Amendment DOJ goes shopping for precedent in the Ninth Circuit's case history, it reveals their true priorities. They're not looking for ways to protect gun rights. They're looking for ways to restrict them while maintaining political cover. The language they use to describe firearms should terrify every gun owner, regardless of what you own. Short-barreled rifles are characterized as easily concealable weapons frequently associated with criminal activity. Short-barreled shotguns become devastating short-range weapons preferred by violent offenders. Suppressors, which many European countries sell over the counter as hearing protection devices, are labeled as tools that facilitate criminal activity. This isn't accidental phrasing or careless writing. This is deliberate legal strategy designed to build precedent for future restrictions. Once a federal court accepts these characterizations, that language becomes available for use in cases involving different firearms. Today it's short-barreled rifles. Tomorrow it could be your concealed carry pistol or home defense shotgun. The framework they're creating allows any firearm that isn't a full-length hunting rifle to be characterized as presumptively dangerous and appropriate for registration or prohibition. They're not just defending existing law, they're building the legal architecture for expanded gun control that could eventually encompass virtually every firearm Americans currently own. Members of Congress recognize this danger immediately. 23 representatives who voted for the bill eliminating the NFA tax sent a formal letter to the Department of Justice. The letter explicitly stated that eliminating the tax was intended to begin deregulating these items. It reminded the DOJ that Congress, not executive agencies, holds legislative power under the Constitution. The DOJ's response was silence. No formal reply to Congress, no acknowledgement in their court filings. When they finally addressed congressional intent in their brief, they dismissed it in a single paragraph, arguing that how Congress characterizes a law doesn't control how courts interpret it. Technically true, but completely missing the point of constitutional separation of powers. The executive branch has a duty to faithfully execute the laws as written by Congress. When Congress writes a law, explains their intent, and eliminates the constitutional foundation for a regulatory scheme, faithful execution requires acknowledging that change. Instead, the DOJ is executing the law as they wish it had been written, not as it actually exists. What makes this betrayal particularly dangerous is the nature of the NFA registry itself. This isn't just a list of serial numbers in a government computer. It's a comprehensive federal database containing names, addresses, fingerprints, and photographs of millions of law-abiding citizens. These people committed no crime. They simply wanted to exercise their Second Amendment rights with certain categories of firearms. The risks aren't theoretical. In 2022, ATF accidentally published personal information of thousands of NFA registrants online. Names, addresses, and details about their registered items became publicly searchable before someone caught the mistake. In 2019, a disgruntled ATF employee leaked registry information to anti-gun activists who used it to harass gun owners. Yet the DOJ's brief treats registration as a harmless administrative requirement, no different than getting a driver's license. They argue that since registration doesn't technically prohibit ownership, it doesn't burden Second Amendment rights. This ignores decades of Supreme Court precedent holding that registration schemes can function as de facto prohibitions by making compliance so burdensome or risky that people simply don't exercise their rights. The case is currently before Judge James Wesley Hendricks in the Northern District of Texas. Both sides are fighting over summary judgment, which means the case can be decided purely on legal questions without a trial. The facts aren't disputed. Congress eliminated the tax. The registry still exists. The DOJ is defending it. The only question is whether that's constitutional. The plaintiff's position is elegantly simple. The Supreme Court upheld the NFA under Congress's taxing power. Congress eliminated the tax, therefore the taxing power justification no longer applies. 3 sentences of clear logic supported by the Supreme Court's own precedent. The DOJ's counter-argument requires pages of creative interpretation and reliance on overruled precedent. When you need 48 pages to explain why your position makes sense, and your opponent needs 3 sentences, you're probably on the wrong side of the law. What happens in this case matters more than every campaign speech or political promise about gun rights. Politicians can talk about supporting the Second Amendment until they lose their voices, but your actual rights are determined in federal courtrooms when government lawyers argue about constitutional interpretation. If the court rules that eliminating the tax eliminated the constitutional foundation, the implications extend far beyond suppressors. The entire legal theory supporting federal gun registries collapses. Future attempts to create registries for pistols, semi-automatic rifles, or any other category would face immediate constitutional challenges using this precedent. The ATF would lose its primary tool for tracking and controlling firearms ownership. Most importantly, it would establish that Congress can eliminate gun control measures by removing their constitutional justifications, and courts will enforce that elimination even when executive agencies resist. Gun rights organizations are watching this case closely. If Silencer Shop wins, expect immediate challenges to every aspect of the NFA. The machine gun registry closure, arbitrary definitions of what requires registration, prohibitive compliance costs, and criminal penalties for paperwork violations all become vulnerable. This is how real change happens in America. Not through campaign speeches or press releases, but through court decisions that bureaucrats can't ignore or reinterpret. The DOJ's brief reveals their true priorities, and those priorities have nothing to do with protecting your rights. The betrayal runs deeper than just this case. By establishing in federal court that certain firearms are inherently criminal in nature, they're creating precedent that future administrations will use to justify expanded gun control. When the next anti-gun administration takes power, they'll point to this brief as evidence that even pro-gun administrations recognize the need for registration and control. Every gun owner needs to understand what's happening here. This isn't about technical legal arguments or obscure constitutional theories. This is about whether the government can maintain a comprehensive database of law-abiding citizens exercising constitutional rights even when Congress has removed the legal justification for that database. The DOJ had a choice. They could have acknowledged that Congress eliminated the constitutional foundation for NFA enforcement. They could have worked to implement the will of the people's representatives. Instead, they chose to fight tooth and nail to preserve a system of registration and control that Congress explicitly undermined. Their arguments reveal a bureaucratic mindset that views gun ownership as a privilege to be monitored and controlled, not a fundamental right to be protected. They're using the same legal theories and precedents that gun control advocates have used for decades, just with better political cover. Share this information with every gun owner you know. The mainstream media isn't covering the depth of this betrayal or its implications for future gun rights. What happens in this case will echo through the courts for decades, either protecting your rights or undermining them. The judge's decision could come at any time. When it does, it will either vindicate the promise of a pro-Second Amendment administration or confirm that the bureaucratic state will fight to preserve gun control regardless of who's in charge. The stakes couldn't be higher, and the betrayal couldn't be clearer. That's it for today, folks. See you in the next video.